talk about cybersquatting, in particular, anti-cybersquatting protection act claims under the Federal Lanham Act. These are a relatively new type of claim under the Lanham Act, only since 1999, after which trademark owners were able to convince Congress that the existing laws of infringement and dilution were not good enough in protecting their marks from being registered on domain name registries, especially by people who were trying to sell them back for high amounts of money. So Congress enacted cybersquatting to help these companies. Now, what exactly is cybersquatting? Well, the image there is supposed to remind you that it's all about bad faith intent to profit, i.e. make money, simply by registering a domain name. Well, maybe not simply registering it, by registering it as a first step, as a way to perhaps secure financial gain from the company whose trademark it is. Now, a key question is what marks are protected. Is it, for example, only registered marks? The answer is no. Any distinctive mark, and the red pencil is supposed to remind you that it's distinctive, is protected. So any distinctive mark, even if not registered, even if not famous, could be protected under cybersquatting. The next question is whether confusion is necessary. Short answer is no. Just like federal dilution, there is no consumer confusion necessary. Moreover, unlike federal dilution, there can be liability without use of the mark on any goods and services in commerce. Remember that for cybersquatting, you are focused solely on the use of a trademark as the domain name. There never needs to be any goods or services. So the last image is supposed to remind you that you don't have to have any goods. That's why the truck is crossed out. So those are some of the basics, but the big question is, what is bad faith intent to profit from registration? So let's consider some big picture issues. Now, there are a number of bad faith intent to profit factors. Many factors are listed in the statute. You may be wondering, do you need all or at least the majority? And the answer is no. This is a little bit like likelihood of confusion, but it's also different. So for likelihood of confusion factors, most of those factors are intended to help you show that there is confusion. With the statutory factors about bad faith intent, half of them, roughly, are showing that there is likely bad faith, whereas the other half are pointing out what likely is not bad faith. So therefore, since half of them don't even have anything to do with bad faith, you would never need a majority. Now, you may be wondering what would be an easy case of no liability, no bad faith intent to profit. The most common are so-called gripe sites. So let's see, McDonald's sucks.com, Heineken sucks.com, or variations like that. You don't even have to use the word sucks, although that has been commonly used. The idea is that you are only complaining about the mark owner, but there is no intent to make money from registration. Now, the other possible easy case of liability that sometimes appears less common is that the mark is used for someone whose name it actually is. So for example, if McDonald's was someone's surname and they registered mcdonalds.biz, there's not necessarily bad intent to profit from McDonald's, the burger company. Now, you may be wondering, what does suggest bad faith? Well, there are some things that are common. One common thing is trying to divert users to your website where you can sell goods. So this may seem a little bit like trademark infringement, but it's based on registration of a similar domain name. And by similar, we're looking at the stuff before .com, .biz, etc. So if you register Target instead of Target with an IT as opposed to ET for the brand name owner, and you sell the same kind of stuff, that would be diversion. Another factor suggesting bad faith would be actually offering to sell the mark, the registration domain name back to the mark owner. So if you register Target, Targit, and try to sell it back to the big name company Target, that would indicate bad faith. Now, even if you don't try to sell it back, if you simply register many domain names of distinctive marks, that would also suggest bad faith. So all of these are possible things that could suggest bad faith. Courts can also find bad faith in addition to these, but these are common examples of bad faith intent to profit from registration of a domain name that would result in cybersquatting.